Welcome, everybody. Welcome to this edition of Ramblings of an Old Fart podcast. My name is Craig Warren. I'm 71 years old and been married almost 53 years. Father of 9 and grandpa to a bunch. I'm sort of retired. I retired at 65 to provide full-time care for my wife, who's had some pretty serious health issues. But lately I realized I needed something to do to keep my mind active, so why not a podcast? I have a lot of experience. I've done a lot of things in my 50-plus years in the workforce. I have a lot of opinions, so what more would I need? I should mention that I've never been a member of a political party, and I do not intend to do so. My podcasts do not come from a political place, just from a factual and common sense place. So today I want to talk to you. This is my part 2 of our immigration podcast that I started. And I want to go through this with you because we're moving on from the history in the past and moving into why we are where we at in the current situation. The legal landscape for undocumented immigrants in the U.S. has shifted from a matter of local tolerance, like it was in the 1800s, to a highly complex, federally dominated system that we have today. Kind of confusing sometimes. The core tension in the U.S. law is between plenary power, the government's right to control its borders, and the 14th Amendment, which grants due process and equal protection to all persons within the U.S. regardless of status. I think we have some misinterpretation of the 14th Amendment. We're going to go into that a little bit. But it should be apparent to anyone with even a modest amount of intelligence that we have an immigration problem. So in this part 2 of this podcast, I want to dive into how we got here part. I hope I can press on everyone how serious this is. Out of control immigration has destroyed countless of countries and dynasties and empires over the centuries, as we discussed part of those in our part 1. And our fate will be no different if we don't fix this problem, and soon, like tomorrow. For the first century of the U.S., illegal immigration essentially didn't exist in a legal sense because there was no federal laws prohibiting entry in pre-1980 or 1882 because there was no need. You think about it. After we got the Constitution, we actually got our country the separated from Great Britain. We had this huge country to fill up. It's kind of like that manifest destiny idea. So there was no need. There was no government programs or anything like that. So if people came here, hey, come here. Spread out, build the country. We're okay with that. The problem is, at some point, some of the states like New York and California, because of the bigger cities, because of the increased immigration, especially in California with the Chinese immigrants coming in to build a railroad, other things like that. And then in New York, there was huge. So those cities were being overwhelmed. So they started passing some of their own laws. And so then the federal government started to see this could be a problem here. So then they started working on different things to put all of the immigration things under a national umbrella, right? So that it wouldn't be different in every city. That didn't make sense to them. I agree. And of course, this was the passenger case of 1849. That's when it finally was a federal case that decided that it was a federal issue. Okay, during this time, anyone physically present in the U.S. generally enjoyed common law rights. The right to sue, own property, and be free from arbitrary violence. You had the right to be safe, sort of, kind of. These kind of topics in the American legal history were drafted during the Reconstruction era. A lot of this stuff came about after the Civil War. There was a lot of things happened after the war that really shaped how our immigration things started to progress the way they are. Following the Civil War, there was a massive trail of legislative intent, right, found in Congress. It was in the Congressional Globe, which is the predecessor of the Congressional Record. The consensus among historians is that the 14th Amendment had both specific, immediate goals and a broader philosophical purpose. That's what I want to start talking about here. The most direct purpose of the 14th Amendment was to nullify the Supreme Court's decision in Dred Scott versus Sandford, 1857. The Dred Scott decision basically, the Dred Scott said that black people could never be citizens of the United States. So in Section 1, the Citizenship Clause says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. This was intended to guarantee citizenship to formerly enslaved people. By defining citizenship based on birthplace, jus soli, of the soil, rather than race or ancestry, the framers sought to ensure that a person's rights were not dependent on the whim of individual states or cities even. The law didn't distinguish between legal and illegal status. Of course, at that time, there wasn't such a thing as illegal status. It hadn't been an issue until this point when it became in such high numbers that something had to be done. Okay, so the framers, led by Representative John Bingham, often called the father of the 14th Amendment, they were concerned that southern states would pass black codes, laws that applied only to black people and essentially recreate slavery in everything but name. So that was kind of the point of the 14th Amendment, to address these issues. It kind of was designed to provide a federal shield against state-level tyranny or slavery. The amendment intentionally used the word person rather than citizen for the due process and equal protection clauses. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Okay, so during the debate over this whole thing, Bingham and Senator Jacob Howard explicitly stated that these protections were meant to apply to all human beings living within the borders of a state, ensuring that basic rights like a fair trial or protection from violence were universal. The immediate intent, the Civil Rights Act of 1866, right? And the 14th Amendment was essentially an upgrade to that Civil Rights Act. Republicans in Congress were terrified that if Democrats regained power, that they would simply repeal that act, that Civil Rights Act of 1866. By moving the language into a constitutional amendment, they locked in the rights of formerly enslaved people. See, it's a lot harder to change an amendment to the Constitution than just simply pass an act. That's the problem I see right now. I want to just mention this. We see these referendums, these ballot initiatives to change and take away the authority of the state legislatures to redistrict and put it into the hands of commissions. Okay? The problem is we have judges that are allowing this to happen when it is totally unconstitutional. See, our constitutions, every one of them, our federal and every state, has in it an article which describes exactly what it takes to change an article of a constitution. It takes an amendment process. The problem is, as I see, I've had several instances here. I'm getting ready to do some podcasts on some of this. But right now we have states that have used this, right? They've done this and changed it illegal, but now California, because they have such a high number of Democratic people in their legislature, they believe that now they want to go back to the legislature because they can redistrict in a much more advantageous way for the Democratic Party. See, that's the problem. See, here in Utah, they passed this Prop 4. Immediately, a group started another ballot initiative to go in and overchange that and change it back to the way it was. And that's what these things cause. If we don't follow the proper procedure, we bastardize our constitutions to the point where they become useless. We can't have these things every 2 years changing back and forth and back and forth. We need to do it the right way. And that's my soapbox moment for the day right there. Okay, the primary purpose, although, was to ensure that the birth on U.S. soil was the sole requirement for citizenship, thereby stripping states of the power to decide who was American, based on race or whatever they wanted to. Okay, so this is the phrase at the heart of my research during the debates. Senators explicitly asked what jurisdiction meant, right? Two primary views emerged. Senator Jacob Howard and Senator Lyman Trumbull, the principal authors of the 14th Amendment, argued that subject to the jurisdiction meant more than just obeying the laws. Trumbull's definition was, he stated it meant not owing allegiance to anyone else. Howard's definition, he clarified that it meant full and complete jurisdiction, specifically excluding the children of foreign diplomats who owe allegiance to their home monarch or state. So other senators, such as John Conness from California, pushed for a broader interpretation. See, in California, of course, they had a lot of Chinese immigrants. And he was asked that if it would make the children of Chinese immigrants citizens. And he responded firmly, I am in favor of it. He argued that even if the parents were transactional laborers who couldn't become citizens themselves, their children born here should be treated as full Americans to prevent a permanent alien class. But what he didn't consider is what happens, because a lot of these, we discussed it in part one, these sojourners, they came here and had no intentions of staying here. They came here to make as much money as they could and then go back to China to live wealthy lives. So what happens when you take their children back to China as U.S. citizens? That creates quite a stir back in China, I'm sure. Anyway, moving on. The framers did intend to exclude certain groups based on the 14th Amendment, and they have stated so. Of course, we mentioned the foreign diplomats. Their children are born on U.S. soil but owe no allegiance to the U.S. and are immune to its laws. So they are not automatically considered citizens. Native Americans, you have to understand, though, at this time, they were viewed as members of sovereign tribes, right? At that time, the Native Americans on their reservations, even if they'd been moved to reservations, they were considered a sovereign nation. So there was no point claiming their children were U.S. citizens. They were members of their tribe. So the 14th Amendment, in order for that to grant them citizenships because of their primary loyalty, was to their tribe, not to the U.S. This was eventually changed by the Indian Citizenship Act of 1924. However, at that time, some of the Indian nations were not thriving very well, and so it was decided that it would be best to bring them into as U.S. citizens. The other one, and I found this very interesting here, if a foreign army occupied a U.S. city and a soldier had a child there, that child would not be a citizen because the birth happened under hostile occupation, not U.S. jurisdiction. So there were some exceptions, and I think that our court system has got this wrong. I'm hoping we have this Trump versus Barbara case that's coming up before the Supreme Court, should be decided within the next month or so, that's going to address this issue. I certainly hope they get it right this time. Okay, since the framers required allegiance, based on what they said, they would never have granted citizenship to the children of people who broke the law to get here. See, that's a valid point, I think. But since the Supreme Court later ruled in Wong Kim Ark in 1898 that jurisdiction simply means being subject to U.S. laws and courts, the status of the parents is irrelevant to the child's right under right. But here's my issue with this. I mean, they said that it was irrelevant to the child's right to be a citizen, but under international law, right? International says that the child has the citizenship of their parents until the child himself decides to change it. And that's the way China feels about it. Any of their citizens here, if they had children born here, they were Chinese. And that's what international law says as well. Okay, moving on, Chief Justice Fuller argued that the 14th Amendment was never intended to adopt the crude British common law, jus soli, right of the soil. Instead, he believed American citizenship should be based on jus sanguinis, right of the blood, and consensual allegiance. He argued that jurisdiction in the 14th Amendment didn't just mean being subject to police and taxes. It meant a voluntary spiritual allegiance to the United States. He pointed out that if parents remain subject to a foreign power, like the Emperor of China at the time, they are transactional residents. Therefore, their children are born into a household of foreign loyalty. He feared that birthright citizenship would create a class of citizens who were legally American, but culturally and politically loyal to a foreign empire. Further, Fuller warned that the majority's ruling would create a dual citizenship crisis that would weaken the U.S. during times of war or national stress. If a child is a U.S. citizen by birth, but a Chinese citizen by blood, as Chinese law dictated, the child has two masters. This is exactly the parallel that happened in the Roman Empire. The late Roman Empire, where the foederati, the immigrant soldiers, had a legal status within Rome, but an ideological loyalty to their own tribal leaders. Right? Fuller argued that the 14th Amendment should be a shield for those truly committed to America, not a loophole for those just passing through for economic gain. Fuller's dissent concludes that with a warning that resonates with my research here, into the cost of migration. He argued that a nation is not just a tract of land where people come to make money. It is a voluntary association of people with a common purpose. However, we had dissenting opinions. And so this comes with a warning, though. If citizens become automatic rather than earned or consensual, the national character would eventually dissolve. That's what he said. When citizenship is disconnected from shared values, the country becomes an administrative zone rather than a homeland. Okay, so I just find this so fascinating and yet so discouraging at the same time. We are the only country in the world that I could find that use this of the soil, this jus soli. And that includes all of Europe. Nobody does. It's all the jus sanguinis, the right of the blood, which is designed specifically to prevent transactional citizenship. And I have a thought. The jus soli, right of the blood, makes more sense to me. When children are born, when we have children here, it's our duty as a parent to guide them, make decisions for them, right? We have laws. They can't drive until they're 14, 15, 16-year-olds, depend on the state, and they have to take courses to learn and do all that. They can't buy alcohol or cigarettes till they're a certain age. Those laws are set there to protect them until they get old enough to make the decisions about that kind of stuff. So why would we think it would make any sense to force citizenship on them, especially when that citizenship is in direct conflict to their parents' citizenship? Does that make sense to you? It does to me. I don't see why we would think that would make sense. And of course, international law, that's the way it is. You are, until you voluntarily change and swear allegiance to somewhere else, you are of the same citizenship as your parents. Makes a lot more sense to me. But here's the thing. Critics of this, echoing Chief Justice Fuller's dissent, is arguing that this creates a state within a state, when millions of people live in a country without legal status or allegiance, protected by laws from federal authority. And in this situation, the nation loses its sovereign character, right? Our sovereignty kind of starts to dissolve, and it begins to resemble a collection of competing tribes rather than a united republic. One nation, indivisible, right? There's one more extremely important part of this immigration that I'm not sure most people have heard of and have even considered. And it is, however, one of the more dangerous parts of immigration. And I call it the weaponization of immigration. See, there is such a thing as called the Reconquista, right? The theory suggests that what could not be held by the Mexican military in 1848 is now being reclaimed through demographic presence and cultural persistence. One of the most cited figures in this school of thought was Elena Poniatowska. I'm not sure if that's pronounced right, but she's a famous Mexican author who stated, "The common people are recovering the land through the power of reproduction." See, unlike a traditional invasion, this is a bottom-up shift by maintaining a high concentration of people who keep their native language, culture, and primary loyalty to Mexico. The territory becomes culturally and politically Mexican, right? Again, without even a single shot being fired. That's the whole point. Historically, the Mexican government has encouraged this diaspora, if you want to. Mexicanidad in the late 1990s. Mexico changed its laws to allow dual nationality, specifically so that Mexicans in the U.S. could become U.S. citizens to vote and influence policy without betraying their home country. Does that make sense? We see that happening. You look in places like Southern California, parts of Texas. They look a lot more like Mexico than they do the United States. There's one other issue. We have this issue, and this has been in the news lately. The Trump administration is working hard to put a stop to this, and that's the Chinese. Over the last decade or so, the Chinese have sent tens of thousands of pregnant young women here. Sent them here for, educational visas or whatever. But once here, they have those babies, right? Now they are U.S. citizens, according to our Supreme Court decisions that I think were absolutely stupid, but that's the reality of it. As soon as they have their babies, though, they are sent back to China, where their babies are raised as Chinese. However, when they become of age, they can return to the U.S. again and vote in our elections because they are considered U.S. citizens. See, the 14th Amendment drafted to provide a moral and legal foundation for a post-slavery republic unintentionally created a civilizational loophole by shifting the definition of personhood and citizenship from consensual allegiance, as argued by Chief Justice Fuller's dissent in the Wong Kim Ark case, to mere geography. The U.S. decoupled the benefits of the state from the loyalty required to sustain it. And I'm here to say I don't think that 14th Amendment did that. I think our Supreme Court, in some of the stupid decisions they made, have done this to us. But anyway, this has allowed this modern transactional resident thing to claim the protections of the U.S. while maintaining a primary allegiance to foreign power. If a state prioritizes the transactional, the cheap labor, and the economic growth over the ideological one, the shared language, the shared culture, the loyalty, all of that stuff, it eventually becomes a geography, a place where people reside, but no longer a nation that they will defend. The crisis I see is not one of people, but one of purpose. The weaponization of migration only succeeds when the host civilization has lost the ability to define who belongs and why. To avoid this fate of some of the fate of some of the other great empires that we've talked about in the past, a modern republic must reconcile its universalist legal ideals with the cold reality of sovereignty and the survival of their sovereignty. A lot of people believe that this modern immigration from Mexico is just poor people trying to get here for a better life, and a lot of them are. But there's a whole lot more going on than just that. Consider this: Mexico has 53 consulates in the U.S. The only other two nations that have an even close to that number is China and Russia, who have 7 and 6, respectively. Evidence shows that a lot of the push for this reclaiming land lost to the U.S. is fostered through their consulates. If you need further evidence of that, more complete facts, see Peter Schweitzer's book, The Invisible Coup. That'll fill you and that'll open your eyes, I'm sure. Last thing I want to just mention here is this Trump versus Barber case. This is one that hopefully will resolve this 14th Amendment issue. And I hope they get it right this time. They should be coming up with a decision within the next month or so. So I'm looking forward to see what they come up with. I don't always hold out a lot of hope with our Supreme Court these days or any of our court systems, but I'm hoping they get it right this time. Anyway, I'll leave that with you today. I hope you found it entertaining or thought-provoking or something. Thank you for joining me. I hope you found it very entertaining at least. Join me next time, won't you? I'm Craig Warren. This has been the Ramblings of an Old Fart podcast. God bless and keep you till next time. Thank you.